And sixth, when a proclamation under Article 356 is in force, there are innumerable decisions which are taken by the union government on behalf of the state government for the purpose of day-to-day administration. Every decision and action taken by the union executive on behalf of the state is not subject to challenge. Opening up challenge to every decision would lead to chaos and uncertainty. It would in effect put the administration in the state at a standstill. Therefore, the following standard is laid down to assess actions under Article 356 after the proclamation has been issued. A. The exercise of power by the President under Article 356 must have a reasonable nexus to the object of the proclamation. B. The person challenging the exercise of power must prima facie establish that it is a mala fide or extraneous exercise of power. After a prima facie case is made, the onus shifts to the union to justify that the exercise of power had a reasonable nexus with the object of the proclamation. And C, the exercise of power by the President for everyday administration of the state is not ordinarily subject to judicial review. The argument of the petitioners that the union government cannot take actions which have irreversible consequences when a proclamation under Article 356 is in force is not accepted. The power of the legislature of the state under Article 357 to repeal or alter or amend a law enacted by Parliament in exercise of the power of the legislature of the state must be read in the context of the amendment introduced by the Constitution 42nd Amendment Act 1976. Before the amendment, the law to the extent of incompetency would automatically cease to exist after a buffer period and actions done were expressly saved. However, an express repeal by the competent legislature is required for the law to cease to exist after the amendment. The repealing statute would in such case make provisions for actions taken during the subsistence of the legislation. The observations in Krishna Kumar Singh on whether the consequence of an ordinance can subsist even after the ordinance ceases to exist cannot be transposed to interpret the limits of Article 356 because an ordinance which has the effect of a law by its very nature has a limited life.